What is the difference between a hearing and a trial? Hey everyone, my name is Hannah with Solo Suit, and if you've been sued for debt, you may find yourself asking this question. You might even have a hearing or a trial scheduled and coming up and are wondering the best ways to prepare for it. Well, in this video, I sit down with a real attorney named Sarah Wolk, and we go over some questions about hearings versus trials and the best ways to prepare for them. Thanks so much for watching, and I hope that this helps you find some answers to your questions about the debt collection lawsuit process.
Can you tell us a little bit about the difference between a hearing versus a trial in California, how that works?
Yeah, so a trial is going to give you an actual final outcome of a case. Of course, you can appeal that, but it's the end of the trial court. Then a hearing is going to be something prior to trial. So this is going to mostly be things like status conferences and motion hearings. So the judge is going to be involved in kind of making sure that the case moves along. And that's the main purpose of things like status conferences or case management conferences. They want to make sure that the parties aren't just sitting back doing nothing, wasting the court's time. They also will help with motion hearings. That's also a hearing and not a trial. There will be an actual outcome, like a ruling on a motion where a motion is granted or denied. And that sounds kind of like a really big deal, and it can be, but it's also not a final outcome of a case. There can be a party that loses 5 motions in a case and then wins a trial anyways. Obviously, if you can do well on motions, you get more of what you want during the case, which might increase your chance of winning at trial, but it doesn't mean that you won't win at trial. So that's the biggest thing, is trial is really the end of the case, and everything else before that is just kind of leading up to trial, even if there are certain decisions made in those hearings.
Okay, so at trial though, that's where you might have the judge lead a conversation between you and the plaintiff in trying to either come to an agreement or just hearing both sides and then making a ruling based on what they heard, right?
Sort of. I mean, that's where the parties actually have to present their case. So the judge is going to lead the way less at trial. In the hearings, the judge will actually kind of lead the way on what they want. But at trial, the plaintiff has an obligation to actually present evidence. So they have to say, I'm calling Hannah as my first witness, and then ask you questions. The attorney for the plaintiff actually has to ask you questions. The judge can ask questions too, but they don't have an obligation to do so. And if the plaintiff is unable to present evidence to support their case, they lose. So trial does require a lot more preparation. It's going to be more formal, and it is difficult a lot of times for consumers to handle trial on their own, but it's not impossible. And you want to have all of your evidence there with you, witnesses and documents and everything, and be prepared to actually go over it in front of the judge and also sometimes jury.
So it sounds like the trial is maybe more your stereotypical, what you think of when you hear of a trial in a movie, where the judge is there with the jury and you're calling up witnesses and asking them questions and just trying to prove your point or prove your case, your side of the case, right?
Yeah, exactly. Like all the TV shows that we watch, they go to trial on like day 2. The thing that they show in the courtroom is almost always the trial. Now, you're going to wait a lot longer for your trial than that. It's very unrealistic to go to trial that quickly, but that's what to expect, where there's a witness sitting next to the judge and then the attorney is walking around asking questions. Now, the attorney's not going to be walking around. That's also a little bit unrealistic most of the time, but that's what's going to happen, where there's actual question asking by the attorney or the defendant, and not as much the judge. The judge is going to be ruling on things like objections, but not questioning witnesses.
I really hope that this video was useful, and if you've been sued for debt, I hope you know you're not alone. Solo Suit is rooting for you, and that is why we share conversations like the one I just had with Sarah. It's to help individuals know how to resolve disputes and resolve debts. So if you have any other questions or you want more information, please reach out to us at support@solosuit.com or check out our website. As always, thanks so much for watching and good luck with resolving your case.